Yes, ma'am.
And Mr. Paredes is on probation in cause numbers 16-24053, that one for prohibited weapon possession, 20-35328 for aggravated assault causing serious bodily injury, and 20-35329, also aggravated assault causing serious bodily injury. Was in court previously, entered pleas of true to counts 1, 2, 3, and 6. I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
Nothing with that.
Any testimony with regard to any of the other allegations? Mr. Smith?
Judge, we have Mr. Hutchins here for...
I'm sorry, I can't hear you.
We had the probation officer here, if you'd like to hear from him. I believe that, yes, I did address...
I mean, I have what he put in here, but I just am asking if there's any witness, if you want to put in on any testimony for the counts that were not pled true to or not.
I would ask him a few questions if the state's not going to call him.
So I guess we will do.
The hearing began with Mr. Patton taking the oath and confirming that his statements would be truthful. The discussion then moved to Mr. Pess's probation requirements, including community service and mandatory alcohol and drug screenings. Officials confirmed that he had not finished his required community service hours or provided full proof of completion. They also stated that he failed to attend several scheduled screening appointments on June 18, June 25, July 5, and July 21, 2025. When asked about the progress he had made, the court heard that Mr. Pez completed 169 out of the 300 required community service hours, leaving 131 hours unfinished. Records also showed that his last completed community service shift was on April 4 of this year.
Okay.
Which leaves him with 131. He last performed community service on April 4th of this year. He worked with our work crew at my Beaumont office. He has not performed any of the community service in either of the other two cause numbers.
Okay, thank you. Mr. Kimler?
Shouldn't the community service be concurrent in all three of the cases? In other words, the community service that he's done in one case should...
And then we gave him probation on two after that.
It is typically how we do that, Your Honor. We typically will give them credit for community supervision on any of the cases they're doing for us, regardless of when they started supervision.
Community service.
Yes.
Yeah.
Sorry.
May I proceed, John?
Yeah.
How long have you supervised Mr. Patton?
So I'm a supervisor at our department. I've seen Mr. Paredes on numerous occasions for administrative hearings, case staffings, and when I've held down a caseload when we've been in between officers.
But you have some familiarity with him?
I do, yes, sir.
And during the times that you supervised him directly, has he maintained proper demeanor with him?
Yes, sir. Yes.
Proper decorum, all those things?
That is correct, yes, sir.
And should he be continuing on probation, you would not be the supervising officer, that would be someone else, is that right?
That is correct. I would not be supervising him.
Well, let's say, I suppose you acted as a supervising officer at some point in your career at the probation department, is that right?
That is correct, yes, sir.
Assuming, let's just speak hypothetically, if you were a supervising officer again, would there be anything about Mr. Paredes that would cause concern to continue to supervise him as far as his demeanor and decorum and attitude towards the probation department or personnel?
Hypothetically, no, not concerning those items.
Who was his supervising officer?
His supervising officer was...
The court was informed that Mr. Paredes had previously been supervised by Officer Alexandria Ariana. After she went on maternity leave and later decided to remain at home with her child, another officer took over the position. The new supervising officer confirmed having full access to the previous records. When questioned about possible mental health concerns, the officer stated there were no records showing any evaluations, recommendations, or documented conditions connected to Mr. Paredes. The judge then referred to statements made during the updated report, where Mr. Paredes admitted he had been on probation since he was 18 years old and felt overwhelmed by the process. He explained that At the time, he was struggling emotionally because of traumatic events from his past, including being injured in a shooting that affected his neck and arm. Mr. Pedates shared that since the incident, he has experienced ongoing emotional struggles, severe stress, mood swings, and recurring nightmares. He told the court that some days are manageable, while other days are much more difficult for him mentally and emotionally.
At this point, I know since being in jail now, this isn't what I want because it's just hurting my family, hurting my daughter, and being around the people that's around me, being around murderers and rapists and, aggravated robberies and all that. It's just a bad environment for me, and it puts me in a bad mood, puts me, in a bad mindset, I guess you can say. And I did speak with the counselor I had that they assigned me for probation, and I did tell her those things, and they did recommend MHMR, but I never went just because I felt like it was I felt kind of low, of thinking I would go to MHMR, because
Stigmatized.
yes sir. So at this point, I don't want to go to jail or to prison. Feel like being in here, sitting in here, has helped me realize that my life is on the line and it isn't a game and it isn't a joke. And but I do need help mentally. I was prescribed Zoloft the last time I was in here due to my PTSD, but I never took it. Because I heard really bad things about it. But now I'm starting to realize maybe I should be on Zoloft just to control the urge of smoking weed and that kind of behavior.
I could ask him a few questions, Ron.
Sure.
I'm
Wait,
sorry, Ron.
best you can, raise your right hand. Do you swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Go ahead.
Mr. Pedates explained the meaning behind several of his tattoos during the hearing. One tattoo represents his daughter's birthday, while another marks the date his cousin passed away after taking his own life. He shared that these losses happened shortly after other close family members had also passed away from cancer, making it an extremely difficult period for him emotionally. He told the court that he decided to turn himself in about a week after learning about the warrant. Mr. Peeds also clarified that none of his tattoos are connected to gangs or criminal groups. When asked about work history, he said he has consistently tried to stay employed, even taking fast food jobs when needed. His most recent position was at Shipley's Donuts after being laid off from construction work. Before that, he spent around a year and a half working as a carpenter and scaffold builder at the LG plant, helping build wooden structures such as decks, carports, and temporary work areas. The discussion then shifted toward the serious nature of the charges listed in his criminal record, including incidents involving serious injuries, as the court continued reviewing his background.
Shot during that interchange, is that
Yes,
right,
sir.
by the other people?
Yes, sir.
And you would return fire?
Yes, sir.
That's not
I
what,
understand, Your Honor, but it's not, I don't want the court to think, I'm just looking at it, and I'm not trying
my
to.
understanding from the version in the pre-sentence report previously, and
I didn't represent him.
my recollection of it actually, because it's not good when I remember you. The fact that you were already on probation for a felony,
Right.
and then you came in and you admitted that you went there to shoot. You went there to go shoot Christy, which is your child's mother, right? That's not true? No? So did you mean to go shoot the two girls that got shot, Alexis and Taylor?
No, ma'am.
Who'd you mean to shoot?
I didn't go there to shoot anybody.
I think as he explained it to me, he was going there to meet for sexual purposes the two girls, and when he got there, he was set up in the parking lot, and then by other people there, by people who were going to rob him, and in the course of that, there was a gunfight. But he wasn't going there to shoot anybody.
All right, well, that's,
He was
again,
going there for an illegal purpose, to
that
have
goes
sex
against
with
everything
them.
that was said and everything that he agreed to back then, because,
That's correct, Judge. We were getting ready for trial on this case.
Yes.
He was the aggressor. He was the one that fired first, and had he been a better shot, Alexis and or Taylor might
Sure.
have been killed, but he was there to go kill Christie.
I didn't represent him in
okay.
that, so I don't know.
All right. Anything else? All right, Mr. Smith, argument?
Judge, I would agree with the probation that I believe he's only asking for safety now simply because it's the only alternative he sees to prison. I don't think he's sincere about it. We have given him chance after chance after chance, and he has squandered, wasted, and even though he's a nice guy when he shows up, he does what he wants to do. That's evidenced by the jail reports that shows that they tell him to go back to his bunk and he just gets in the shower with his jumper on. And then when they write him up about it, then he says, man, fuck.
The prosecution argued that Mr. Pades repeatedly showed disrespect toward authority and failed to follow the rules he was expected to obey. Prosecutors claimed his behavior demonstrated a lack of responsibility and asked the court to impose a prison sentence. They also questioned whether his emotional struggles should excuse his actions, pointing to the seriousness of the original incident. In response, the defense explained that many of the claims mentioned in jail reports had not been fully challenged or reviewed in court. The attorney asked the judge to carefully consider that those accusations had not been directly examined through questioning. The defense also stressed that Mr. Pades has been dealing with serious emotional and personal struggles for a long time. His attorney argued that his difficulties should not simply be viewed as stubborn behavior or refusal to cooperate. Instead, they urged the court to recognize the impact these issues may have had on his ability to follow probation requirements. The attorney further pointed out that there were no new criminal accusations involved in the case, and that the current concerns were related to probation compliance. While acknowledging the violations were important, the defense requested that the court give Mr. Pades another opportunity with stronger mental health support, treatment programs, and continued supervision to help address both emotional challenges and possible substance-related issues moving forward.
All right, thank you, Mr. Kimler. So, Mr. Paredes, the thing is, you've been given exactly what Mr. Kimler is asking for. You've already been given that. You said it yourself. They recommended Spindletop. They recommended medications. You made conscious decisions not to follow through with what they knew was best for you, which is part of your probation. Everything that they say you should do is a court order. The fact that you are on a probation for possession of a prohibited weapon, like you said, from back when you were 18 years old, put you on a probation, 10-year deferred for that, November of 2016. Then we're back here, you're put on probation for 10 deferred on 2 aggravated assault causing serious bodily injuries in March of 2022 for shooting 2 girls. And you got shot in self-defense. And it appears that there's no real reason for me not to believe that that's how it happened for a number of reasons. No one else was charged with aggravated assault for shooting you. All the police reports, everything that went through in those pre-sentence reports previously that I have copies of, all makes it appear to be true that you went there to shoot either Christy and or whoever else. And luckily were not a good shot. One of the girls got shot 3 times and survived it. And for you to say you have PTSD from getting shot, I can't imagine what she has. I feel like you've been given every opportunity. And when I look back on some of these times where I give chances like I gave you, it's very frustrating and a little embarrassing because it looks like I was not really thinking clearly then. I understand that these are drug allegations. You've been getting opportunities to get help. I mean, you've been on probation since 2016. With every opportunity possible. So at this time, In cause number 16-24053, I'm going to, also based on the evidence presented today, I am going to find count 5 true. So that makes you pled true to counts 1, 2, 3, and 6. I'm finding count 5 true based on that evidence in each of the cases. Find sufficient evidence in that case to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Sentence you to a term of 7 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 20-35329, also find counts 1, 2, 3, and 6 that you pled true to those freely and voluntarily. Find them true. Also find count 5 true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault causing serious bodily injury. Sentence you to a term of 12 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in that case. In cause number 20-35328, again, find that you pled true to counts 1, 2, 3, and 6 freely and voluntarily. Find those counts true. Make a finding of count 5 true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault causing serious bodily injury. Sentence you to a term of 12 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will also be an
The
affirmative
judge
finding
announced
of a
that all
deadly
3
weapon in that
sentences would be
case.
served at the same time rather than separately. Mr. Peeds was then provided with court paperwork explaining his limited rights to appeal the decision, and he was instructed to review and sign the documents with his attorney. The court also issued a formal warning explaining that, under Texas law, he is no longer allowed to possess firearms or ammunition because of the convictions entered against him. The judge advised that violating those restrictions could result in additional criminal charges. Mr. Petades was told to carefully read the written notice, which explains what legally qualifies as a firearm and how long the restriction may remain in effect. The judge added that any further legal questions could be discussed with his attorney. The hearing concluded with the court noting an official finding connected to the use of a deadly weapon in the case.